You have a debt you stopped paying years ago. You never heard from anyone. You figured the clock ran out. You figured you were safe. Here's what you didn't know. One phone call, one sentence, one payment of any amount can legally bring that debt back to life. And debt collectors are counting on you not knowing that. In this video, I'm going to show you exactly what restarts the clock, which states give collectors 10 years to come after you, and the one mistake that people who know all of this still make. Stay with me. This one is going to change how you handle your phone. Picture this. A few years back, you had a rough stretch. Maybe you lost a job. Maybe you had unexpected bills. Whatever it was, a credit card balance got out of hand. You stopped paying. For a while, collectors called constantly. You ignored them. Then, the calls stopped. The letters stopped. You assumed the debt just went away. Here's the reality. The debt never went away. What happened is that the statute of limitations expired. That's the legal deadline for a creditor to take you to court. Once it runs out, they can still call you. They can still send letters. But if you show up in court and raise that defense, they can't win a lawsuit against you for that debt. Think of it like this. The debt is a ticket. After the statute of limitations runs out, the ticket is still technically valid, but no judge has to honor it. The catch, you have to be in the room to say so. Now here's where it gets dangerous. This expired debt, this so-called zombie debt, has been quietly bought and sold by collection agencies, bought for pennies, because they know something you don't. So let's talk about how the clock actually works. Every state in America sets its own deadline for how long a creditor has to sue you over unpaid debt. That deadline is called the Statute of Limitations. And depending on where you live and what type of debt we're talking about, that window can be as short as 3 years or as long as 10. 3 years, 10 years, same country, same type of debt. Here's how it breaks down. On the short end, New York, North Carolina, New Hampshire, Delaware. 3 years. The clock runs out fast. In the middle, California, Texas, Florida, 4 to 5 years. On the long end, Illinois, Iowa, Louisiana, Missouri, Rhode Island. 10 years. 10 years, people. That means a debt from 2015 is still legally actionable in those states today. Now, when does this clock start ticking? In most states, the clock starts on the date you missed your first payment and never caught up. Not when the account was charged off, not when it was sold to a collector. The moment you defaulted, that's when the countdown begins. But some states count from a different event, so check your state's specific rules before relying on any date. Here's the part that trips people up. The clock running out does not mean the debt disappears. Let me say that again. The statute of limitations only removes the collector's ability to win in court. They can still call you, they can still mail you, they can still report the debt to credit bureaus for up to 7 years from the original default date, regardless of whether the legal window is open or closed. 2 separate clocks, 2 separate problems, and most people only find out about one of them. So right now you might be thinking, okay, I know the clock runs out, I just have to wait it out. Turnovers. If there weren't specific things you could do to accidentally set that clock back to 0. And that's exactly what the next part is about. There are 3 main ways to accidentally restart the statute of limitations on a time-barred debt, and collectors know every single one of them. Trigger number 1, making a payment. Any payment. It doesn't matter if it's $5. It doesn't matter if you're just trying to show good faith. In most states, the moment money moves, the clock resets to 0. This is not an accident. Collectors will call you with offers that sound reasonable. We just need a small payment to keep the account active. Even $10 shows your intention to pay. What they're not telling you is that those $10 just bought them another 3 to 10 years to sue you. Trigger number 2, written acknowledgement. If you write anything, a letter, an email, a text, that admits you owe the debt, in most states, that restarts the clock. Real case. A woman in Florida received a letter about a credit card debt from 2011. She wrote back saying she knew she owed it and planned to pay soon. That letter became the evidence. The collector filed suit the following year. She ended up paying $1,800 on a debt that was legally unenforceable before she picked up that pen. Trigger number 3, verbal acknowledgement. And this is the one that catches people completely off guard. In some states, depending on your state, simply saying the words, "Yes, I know I owe that," on a recorded call can be enough to restart the clock. A man in Texas answered a collector's call. During the conversation, he said, "Yeah, I know I owe that. I just can't pay right now." The collector had the call on record. They used that statement in court. The judge admitted it. The man never showed up to the hearing and lost by default. Now, 3 triggers. Huge problem. But there's a 4th scenario that almost nobody talks about, and it doesn't involve saying anything, paying anything, or signing anything. It involves something you did years ago in a completely different context that can be used to revive a debt you thought was dead. We're going to get to that, but first, I need to show you the industry that was built specifically to exploit everything we just covered. Real quick, you've just seen how the clock works and how easy it is to accidentally reset it. What's coming next is the part the debt collection industry really doesn't want you to know, the business model behind zombie debt. The federal case that proved it's not accidental, and the state-by-state map that determines exactly how long you're exposed and whether you're already in the danger zone. If you don't want to miss the next video on Law Drop, where we cover the legal traps most people walk into without ever realizing it, hit subscribe, not because of the algorithm, because this kind of information is the difference between knowing your rights and losing money you didn't have to lose. Now let's get into the industry side of this. Here's something most people don't realize. The collector calling you about a decade-old debt, they probably paid less than 4 cents for every dollar they're trying to collect. That's not an estimate. That's from a Federal Trade Commission study that analyzed over 90 million consumer accounts. Think about what that means. A $5,000 debt bought for $200. If they get you to pay even $500, that's a 250% return on a phone call. And the older the debt, the cheaper they bought it, which means the older the debt, the more desperate they are to get you to make one small mistake, one payment, one sentence on a recorded call, one email that says the wrong thing. And this isn't some small operation running out of a basement. This is a billion-dollar industry with legal teams, call scripts, and decades of data on exactly which words get debtors to accidentally restart the clock. In March 2023, the Consumer Financial Protection Bureau took action against one of the largest debt buyers in the country, Portfolio Recovery Associates. The CFPB ordered them to pay $24 million, $12 million to consumers they had illegally pursued, $12 million as a civil penalty. And here's what made it worse. This was not their first offense. The same company had been ordered to pay $27 million back in 2015 for the exact same practices. They paid the fine and kept doing it because the math still worked. The CFPB found they had filed dozens of lawsuits against consumers for debts that were already time-barred, counting on the fact that most people never show up to court to raise the defense. And they were right. Most people don't show up. Most people don't know they have a defense, which is exactly why Law Drop exists. So now you know the clock exists. You know what resets it. You know who's buying these debts and why. Now let's talk about the part that depends entirely on where you live. Because in this country, the same debt can be completely unenforceable in one state and perfectly actionable in another. Let's start with the states that give collectors the most time. Illinois, Iowa, Louisiana, Missouri, and Rhode Island. 10 years. If you have an unpaid credit card debt from 2015 and you live in any of those states, a collector can still take you to court today, in 2026, over a debt from 11 years ago. Wyoming gives collectors 8 years, Ohio and Colorado, 6, Florida and Massachusetts, 5, California and Texas, 4, and then there's New York, 3 years. But New York didn't just shorten the clock. In April 2022, New York passed the Consumer Credit Fairness Act, and it changed something that no other state had done. In New York, once the statute of limitations expires, A partial payment cannot restart it. A written acknowledgement cannot restart it. An oral acknowledgement cannot restart it. Collectors in New York are also required to notify you in writing that the debt is time-barred before accepting any payment. That's the law in New York. In most other states, they can take your payment, say nothing, and use it to restart the clock without telling you. Now let's talk about the gray zones, because these are the states where even lawyers disagree. Texas, Georgia, Arizona, Tennessee, none of these states have a clear law on whether a verbal acknowledgement restarts the SOL. Courts in these states have ruled inconsistently, which means if you're in one of those states and you say the wrong thing on a recorded call, it might restart the clock. Or it might not, depending on the judge, depending on the county, depending on whether you show up to contest it. And that uncertainty is exactly what collectors exploit. They don't need to win every case. They just need most people to not show up. In fact, consumer protection research has found that in many jurisdictions, the majority of debt collection lawsuits end in default judgments, meaning the consumer never appeared to defend themselves. That's not because consumers owe the money. In many of those cases, the debt was time-barred. The consumer just didn't know. Now, remember that fourth trigger I mentioned earlier? The one that doesn't involve paying anything, saying anything, or signing anything? We're almost there. But first, there's one more clock you need to understand, and it's the one that confuses people the most. Here's a mistake that even financially savvy people make. They check their credit report. They see the debt is gone, and they assume that means the legal window is closed too. It doesn't. The statute of limitations and the credit reporting window are completely independent of each other. They run on different timers. They start from the same event, your first missed payment, but they don't end at the same time, and they don't affect each other. Let me break this down clearly. Clock number 1, the statute of limitations. This is the legal window for a collector to sue you. Depending on your state, 3 to 10 years. Once it closes, a court should dismiss the case if you show up and raise the defense. Clock number 2, the FCRA reporting window. This is how long a debt can legally stay on your credit report. 7 years from the date of your first delinquency, regardless of whether the SOL is open or closed. Now here's where the trap lives. Scenario 1, your debt is time-barred. The SOL has expired. A collector cannot win in court, but that debt is still sitting on your credit report, damaging your score, affecting your ability to rent an apartment, get a car loan, or sometimes even get a job, until that 7-year window closes, separately, on its own timeline. Scenario 2, and this one trips people up even more, the debt has aged off your credit report. You don't see it anymore. You think it's gone. But the statute of limitations in your state is 10 years, and you're only in year 8. A collector can still file a lawsuit against you. The debt is invisible on your credit, but legally, the door is still open. 2 clocks, running independently, both capable of hurting you in completely different ways. And most Americans only know about one of them, the credit report side, because that's the one that shows up when they apply for something. The legal side stays invisible, until a process server shows up at your door. Now, we've talked about 3 triggers that restart the SOL. I promised you a 4th, and this one is different, because it doesn't require you to do anything deliberately. It can happen because of where you used to live. Before we go further, everything in this video is for informational purposes only. It is not legal advice. Debt collection laws vary by state, and they can change. If you're dealing with an active debt collection situation, talk to a licensed attorney before you take any action. Many consumer rights attorneys offer free consultations for exactly this type of case. Now, here's what you need to know. So, a collector calls. It's about an old debt. What do you actually do? Here's the protocol, step by step. Step 1. Do not confirm the debt is yours. Not on that call, not in any way. Don't say, yes, I know I owe that. Don't say, I was going to call you about that. Don't say anything that connects you to the debt. You can say, I'm not going to discuss this over the phone. Please send me everything in writing. That's it. That's your entire response. Step 2. Request a debt validation letter. Under federal law, the FDCPA, if you're dealing with a third-party debt collector, which is the case for most zombie debt, you have the right to request written verification of the debt. Send a written request within 30 days of first being contacted. Once you send that request, the collector must stop all collection activity until they provide written verification. What should that letter include? The name of the original creditor, the amount owed, the date of the original delinquency. That last one is critical, because that date is what you use to calculate whether the statute of limitations has already expired in your state. Step 3. Never make any payment, not even a test payment, not even $1, before you know the original delinquency date and whether the SOL has expired in your state. In most states, that $1 resets everything. Look up your state's statute of limitations. Compare it to the original delinquency date. If the SOL has expired, you have a defense. Step 4. Keep everything in writing. If a collector offers you a settlement, get it in writing before you pay a single cent. If they say the debt won't restart the clock, get it in writing. Verbal promises from debt collectors are worth exactly nothing in court. Step 5, and this is the most important one. If they file a lawsuit, show up. I cannot stress this enough. The majority of debt collection cases that collectors win are won because the consumer never appeared. Default judgment, no contest. Collector wins automatically. If you show up, if you raise the statute of limitations defense, a judge in most states should dismiss the case, but you have to show up and raise that defense correctly. In many straightforward cases, people have successfully cited the statute of limitations and had the case dismissed. But every situation is different. If there's any complexity, if you moved states, if you made any payments, if the debt type is unclear, a consumer rights attorney can review your case, and many offer free consultations specifically for this. Now, everything I just told you applies in most states, but the rules vary. Some states have additional protections, some have fewer. This is general information. Your specific situation may be different. When in doubt, talk to a consumer attorney before taking any action. Before you take any action on an old debt, check the specific laws for your state, or consult with a consumer rights attorney. Many offer free consultations for debt collection cases. And now, the fourth trigger, the one I've been holding back, the one that catches people who think they've done everything right. Okay, the fourth trigger. Here it is. You moved to a different state. That's it. That's the trigger. And here's why it matters. When you have an unpaid debt, the statute of limitations that applies isn't always the law of the state where you currently live. It can be the law of the state where you originally defaulted. It can be the law of the state listed in your credit card agreement, which is often Delaware or South Dakota, because that's where most card issuers are incorporated. Or it can be determined by something called a borrowing statute, a rule some states use that applies whichever SOL is shorter between the state where you live now and the state where the debt originated. Let me give you a concrete example. You lived in Rhode Island. You defaulted on a credit card in 2018. Rhode Island has a 10-year statute of limitations. In 2022, you moved to New York, which has a 3-year SOL and a law that says partial payments don't restart the clock. You think you're protected by New York law. But the collector files suit in Rhode Island, where the debt originated, where the 10-year clock is still running, and where you have no New York protections. That's legal. In most cases, that's completely legal. And here's the version that catches people who did everything right. You lived in Illinois, 10-year SOL. You defaulted in 2017. You waited out the clock. 9 years later, you're in year 9 of 10. You get a call. The collector knows the clock is almost up. They offer you a settlement. It sounds reasonable. Just pay 30% and we'll close the account. You're tired of it. You pay. You just restarted a 10-year clock with 1 year left on it. They now have 10 more years to pursue the full balance. This is not a hypothetical. Consumer protection advocates have documented this pattern. The closer a debt gets to the statute of limitations, the more aggressively collectors pursue settlement, because they know the clock is almost up, and they know that one payment from you resets everything. So the next time a collector calls, and they will call, you're going to remember this video. You're going to ask for the original delinquency date. You're going to look up your state's statute of limitations. You're going to put nothing in writing until you know exactly where you stand. And you're going to remember, one wrong move doesn't just cost you money today, it can cost you 10 more years of exposure. Think about someone in your life right now. A family member, a friend, a coworker, someone who's been ignoring an old debt, thinking the clock already ran out, thinking they're safe, thinking silence was the right move. They don't know about the triggers. They don't know about the 2 clocks. They don't know that one phone call answered the wrong way could reset years of waiting. Sharing this video isn't about the algorithm. It's not about views for LawDrop. It's about that person getting this information before a collector uses it against them. Because collectors already know everything in this video. They're counting on the fact that you don't. Hit share. Send it to the person who needs it. And if you made it all the way to the end of this one, you're exactly who LawDrop is made for. Someone who wants to understand the system before the system uses it against them. If this was useful, like the video so more people can find it. Subscribe to LawDrop so you don't miss what's coming next. And hit the bell, because the next one might be the one that protects someone you care about. And if this video changed how you think about that old debt, drop the word zombie in the comments. It lets me know this reached someone who needed it. That's what LawDrop is here for. And if you want to see another legal trap that millions of Americans are sitting in right now, the next video on LawDrop covers something your employer is counting on you never looking up. That non-compete agreement you signed when you got hired? In many states, it may already be completely void, unenforceable, worthless. And your boss knows, or should know, that. Depending on the state you work in, you may have the legal right to walk out that door and go work for anyone you want. That one's coming next. I'll see you there.